Hello, this is Michelle Matteson, and this is Legal Aspects of Media, and this is my research case study presentation. First, I'll be covering the New York Times Company versus Sullivan from 1964. Who are the parties in the case, and what facts led to their dispute? The parties in this case are L.B. Sullivan and the New York Times Company, and the facts behind the case are about an advertisement that was posted by the New York Times. In this advertisement, they had a picture of Sullivan with other public officials, and the reason Sullivan got upset over the advertisement was because the caption read, "Heed the rising voices." Under this caption in the advertisement, the New York Times reveals some credible and not so credible information regarding the civil rights movement. One thing the New York Times wrote was, "There's a reign of terror towards everyone that participated in the civil rights movement in the South." Sullivan was upset because his picture was exposed next to the controversial New York Times ad. He felt like they were pointing their finger at him, and also, at the time, Sullivan was commissioner for Montgomery, Alabama's police department. Why did Sullivan feel his reputation was damaged by the New York Times publication? First and foremost, Sullivan had no actual proof that his reputation was damaged due to the New York Times publication. However, an ex-employer of Sullivan did state he would not associate with anybody who would be party to such things that are stated in that ad. In addition, the ex-employer stated he would not re-employ Sullivan. What are the elements of defamation libel? Since Sullivan was a public official, what did the plaintiff have to prove in the case? Alabama's law states any public official who is seeking a libel action against someone who is questioning his official conduct then must first write a letter of retraction to the responder, saying you're going to seek for punitive damages. Now, if the respondent refuses to comply to the request, then the petitioner has the right to seek for punitive damages against the responder who failed to adhere to the petitioner's request. Therefore, since Sullivan was a public official, then he must prove there was actual malice made by the New York Times. Thus, even though the New York Times did provide some false information in their advertisement, the Supreme Court did not consider the information that was stated in the advertisement to be actual malice. In addition, there is no direct implication that the New York Times even accused Sullivan directly within the advertisement. What was the New York Supreme Court's decision, and why did they make that decision? The New York Times won the case against Sullivan because there was no proof of actual malice in the case. Also, there's no direct implication by the New York Times that they were directing their advertisement towards Sullivan. Now let's speak about the case Gertz versus Welch. Who are the parties in the case? Was the petitioner a private person or public figure? The parties in this case are Elmer Gertz and Robert Welch, Inc. And the petitioner, Elmer Gertz, was considered by the court to be a private person, and this was despite the respondent's request for Gertz to be considered as a public figure. Why? Well, Gertz represented a family during the civil trial after their young family member Nelson was killed by Nucio, a Chicago police officer. However, the court felt that Gertz did not meet the requirements that would portray him as a public figure. What are the alleged defamatory statements about Gertz in the American Opinion article? First, Gertz got information from the coroner regarding Nelson's death. He never brought the police officer's name up to the press or the public in general. So there was many defamatory statements that were made towards Gertz in the American Opinion article. For example, Gertz was being accused of being an architect in a frame-up. In addition, the article accused Gertz of being an official to the Marxist League of Industrial Democracy, also known as the Intercollegiate Socialist Society. This society believed in advocating for violent seizure towards the government. The article accused Gertz of being a Leninist and a communist frontier. The term Leninist was named after the Russian dictator Vladimir Lenin, who led his country with an anti-establishment leadership. In addition, the article accused Gertz of belonging to the National Lawyers Guild and saying the guild probably did more than any other outfit to plan the communist attack on the Chicago Police Department during the 1968 Democratic Convention. Also, the article posted a picture of Gertz with the caption saying, Elmer Gertz of Red Guild harasses Nucio. What was done to confirm the accuracy of these allegations against Gertz? First, there was no proof that Gertz had any criminal record, and there was no evidence that he played any part in the 1968 demonstrations in Chicago. Also, there was no basis for Gertz to be called a Leninist and a communist fronter. In addition, Gertz was never a member of the Marxist League of Industrial Democracy. Most importantly, the editor failed to even verify any of these allegations against Gertz. The only thing the editor did say is he conducted extensive research into the Richard Minucio case. The editor distributed the article without even going through the facts, and the story spread across the country and, of course, on Chicago newsstands. How do you think these allegations affected Gertz's reputation? I must agree with Gertz on how he felt that this would damage his reputation. He felt that his reputation as a lawyer was injured, but most importantly, as an American citizen. After all, he was not a well-known lawyer, and he certainly didn't want to consider himself as a public figure. I can only imagine how this defamation would damage his career forever. What would you have done differently than Welch to avoid the lawsuit? First, I would make sure that all my facts check out. I'm not going to mislead the public with any false information. Also, I would not build my reputation as a journalist and have my editor believe I thoroughly examined my information because I've done so in the past. The editor can put trust in me that I won't spread a false information without backing up my information with facts. What is your state's defamation law? New York State's defamation law states any false statement published to a third party without privilege or authorization with fault amounting to at least negligence that can cause special harm or defamation per se. How can you relate what you learned from Sullivan and Gertz cases to your future work in the communications industry? First, I can't assume that I can use a public figure status to get out of a defamation case. Sometimes there will be certain circumstances when the court will not see someone as a public figure or a public official. So I can't assume anything and just say it would be in the public's best interest because the court may not see it the way I do.